The international criminal justice is slow by its very nature. And this often causes public frustration. And if it is unreasonably prolonged the proceedings, it may increase budgetary obligations and budgetary burden of the state parties as far as the ICC is concerned. But what is more is that excessively long proceedings violate fundamental rights of those in detention and on trial. Because every detainee is entitled to trial within a reasonable time, and every accused has the right to be tried without undue delay. And the first post-Nuremberg and Tokyo International Tribunal had to deal with the slowness of the international proceedings at the early stages of its existence. It was 97, 99 when judges and the ICTY as a whole realized that some accused have been incarcerated for 2-3 years awaiting trial. And so the judges in 97, 99, they began looking for procedural means to expedite the proceedings. And then the rules of procedure were amended to give judges more control over the pretrial stage, over the trial preparation stage, to speed up the proceedings. And then to expedite the trials, as you know, new rules were introduced to replace live testimony of witnesses with written statements, quasi-Nuremberg. And then the time comes for the completion strategy, when public was fed up, apparently, with the tribunal that it exists for so long time. And then, with this completion strategy, the rules were amended, and the judges got even more power to control, and they were authorized to direct the prosecutor to select counts of the indictment on which the prosecutor will proceed. At the same time, in the OTP, there were discussions whether to have the prosecution case trial ready by the time that indictment is submitted for confirmation. And of course, this standard is much higher than the standard provided for in the rules, which is prima facie. And then some other amendments were introduced in the rules. But experience of the ICTY, ICTR, and the ICC shows that proceedings cannot and should not be expedited at any cost. In any event, not at the expense of the fairness of the trial, not by restricting the rights of the accused, and not by depriving the prosecutor of the fair opportunity to present its case. Therefore, this panel will try to address general issues such as the main causes of the excessively long proceedings in ICC in this case, the measures which may assist to expedite the proceedings, and the lessons learned so far since 1994 until this day. And as you can see, unlike previous panels, we have 4 speakers, but the same time as any other panel, which means that everyone will have less time than they would like to have. We are supposed to complete our panel discussion by 4:15, although we started later. And then we're going to leave about 30 minutes for questions and hopefully answers from the panel. Our first speaker is Judge Katerina Trendafilova. She is the president of the Kosovo Specialist Chambers, and she was, as you know, was a judge in the International Criminal Court. And we know that judges are always concerned about the slowness of the proceedings. They're the first to be pushing the proceedings to go faster. And Dr. Trendafilova, you will also had the opportunity to draft the rules of procedure for the specialist chambers. And no doubt that you brought your experience from the ICC to incorporate some your experience, especially with regard to the length of the trials and their speed. So if you wish, please share with us your experience in ICC, your experience in drafting of the rules, and how you implemented your understanding of speedy trials in this new institution. You have the floor.
Thank you very much, Dr. Tochilovsky. Of course, I have to say that we are very much disadvantaged, being more on the panel and having much less time. And the topic is extremely important because international, the ICC and international tribunals, also domestic institutions in the criminal justice field have been mostly criticized for being slow, inefficient, and costly. So I will try to limit very much. Of course, I was very much tempted to compare the ICC shortcomings that, of course, we were all experiencing, trying to remedy some of the legal provisions as well as some practices in order to perform up to the expectations of everyone affected by our proceedings and to develop the confidence of the public in this spectacular international criminal court, which is the first of its kind. But I have to limit myself only because of the shortage of time to what was the approach of the judges of the Kosovo Specialist Chambers when drafting the rules of procedure and evidence. And of course, we are all here gathered to pay tribute to the 20th anniversary of the Rome Statute, meaning that we know inside out the normative documents, we know the jurisprudence practices, so you will recognize immediately what measures we took that are in a way trying to avoid some shortcomings, be it in the legal framework, but also in the practices that exist or existed at the ICC. Of course, I would like very, very much to thank Dr. Klaus Rackwitz and his team, Vivian and the rest, because in addition to everything, they were so very generous to us, hosting the first retreat of judges of the Kosovo Specialist Chamber. So thank you very much. Thank you for inviting me, and thank you very much for putting me on this panel, because the length of proceedings have occupied my thoughts, my efforts to expedite proceedings at the ICC, and I was also informed by this when I have resorted to drafting the first draft for the rules of procedure and evidence of the Kosovo Specialist Chambers. Before just enumerating, because time is running, the most important decisions that we have taken and we have reflected in the rules of procedure and evidence that, in my view, are going to expedite proceedings, of course, without compromising the fairness of the proceedings. I would like to mention with you that judges, obviously being guided by their desire to expedite proceedings and to perform up to the expectations of those who have created the institution, victims, those who will be brought to account as well, also demonstrated in the way they have drafted the rules of procedure and evidence, their absolute commitment to this pivotal principle. How we are going to perform that the future will show. But it took me and a very small team of 3 legal officers, Simon Meisenberg, the chef du cabinet, almost a month to prepare the first draft. They need to circulate it to the judges who, from a distance, remotely, provided their comments in the course of 10 to 14 days. And thereafter, we convened the first plenary of judges, at the end of which lasted for 3 days, we have adopted the rules of procedure and evidence. It was an extremely hardworking 3 days, and prior to that, this remote exchange. Everyone was listening to each other, which was very much impressive for me. No one was stuck with the first proposal that the judge had, although I have to acknowledge to you that I was fearful about some very highly established in the legal field, legal minds, that they might appear to be stubborn. That was not the case, which was also very important for me when I'm going to assign judges to the different panels. But be it as it may, let me just share with you the most important approaches that were taken. First of all, we were all in full agreement, and that was also thoroughly discussed in a recent workshop that we had for 3 days, that to expedite the judicial proceedings is the direct responsibility of judges. Judges shouldn't just leave to the legal officers to do their job, and legal officers would approach them from time to time, where do we stand, what you have done? No. To the contrary, judges have to, as soon as assigned to a case, they have to immediately start preparing a work plan, also to mapping all the issues related to the specificities of the case, to enter into consultations during status conferences with the parties, in order for them to establish a target completion date, intermediate deadlines, and to the extent possible, to resolve all problematic issues, even during status conferences, in oral decisions, without resorting to lengthy written submissions and thereafter lengthy decisions. So the next point that I'm going to make is that this was something that we have established at the ICC, but maybe for good reasons, for me not, this practice was abandoned. We were preparing at the pretrial stage, when sending the case to trial, a handover document that was reflecting all the problems that have been resolved at the pretrial stage and those who remain pending, those where there are some immense complications. And I remember that Judge Orio Benito approached me and said, Ekaterina, thank you so much, when they received one big case, because it didn't take us much time to get acquainted with the case and to immediately step into our functions, because you gave us something that put us at ease. In addition, such a handover document would avoid duplication of activities already performed or repetition. So, and of course will ensure the continuity of the proceedings from one stage to another. Next point that I would like to make is that we have established some very strict deadlines. For example, the pretrial stage cannot last longer than 6 months after we are going to be seized by the prosecutor with indictment, and thereafter at most with 6 more months for the preparation of the trial. Then there are some very strict deadlines, not only established for the submission of the parties and so on. I'm very much tempted to share with you an instructive deadline that was established for the issuance of the trial judgment. We have decided that 3 months is sufficient. If not, of course, that's why I highlighted instructive deadlines. Thereafter, this could be extended to 2 more months, and in exceptional circumstances, that of course have to be justified with very solid reasoning in a public decision, which means more for the integrity and the respect for the judges assigned to the relevant chamber. They have to provide these good reasons in a public decision. Then what else we did was also to establish deadlines for the sentencing decision, 30 days at most, if there would be submissions from the parties or hearing additional evidence, no more than 30 days. Then the adjournment of the trial proceedings is possible only up to 21 days. And of course, on very well-grounded basis, it's possible to extend, but also in the decision granting the extension, the resumption date has also to be provided, which is going to have a kind of a disciplinary effect on the judges. Then, of course, I'm very much tempted to share with you that with regard to the interlocutory appeals, in particular, the request for leave to appeal, at the ICC, there were cases where a chamber would receive a request to be granted leave to appeal a decision in January, and the decision was issued at the end of December. So what we have decided that if within 7 days of the request for leave to appeal to be granted, the chamber wouldn't come up with a decision, it is presumed that the chamber has granted leave. So this is going to be another impulse on the judges to expedite if they don't want to grant the appeal. Then the suspect, the person brought to account in this status of a suspect, if within a reasonable time, the prosecutor, and I'm looking now at Mr. Smith, our new prosecutor, that we have very much hope is going to quite soon seize the chambers with a strong case, is not going within a reasonable time to file an indictment, then the suspect, of course, bearing in mind the standards related to human rights, can request the prosecutor either to file an indictment or to terminate the proceedings. If the prosecutor wouldn't do this or would remain silent, then the president should be approached, and the president will appoint a single judge to deal with the matter, and the decision of the judge is final. Then, of course, with regard to investigative measures, and in particular special investigative measures, we did something for the first time on the arena of international criminal justice institutions. We have provided a very thorough regulations of such investigative measures in order to avoid delay, in order to save evidence if evidence was not collected according to the expectations of the judges. Now we quite clearly stated we are not going to accept for the purposes of the prosecutor's case this piece of evidence unless you have properly followed our requirements. Then, of course, about the disclosure, and here I would like to mention something on which we have been disputing sometimes with Fabrizio about the so-called in-depth analysis chart. I'm a person known never to exploit the position that I have. And here is Simon, he could attest to what I'm saying. I didn't put anything to this effect in the first draft that I had to prepare. And then I was very pleasantly surprised by the judges who started raising, even remotely in writing thereafter during the plenary, it was such a good practice because the first requirement for a fact to be evidence is to be relevant, coupled with the rest of the requirements. So why you don't have this reflected here? And then, of course, we proceeded along these lines. We are going to simplify the in-depth analysis chart because that is what Fabrizio and the Office of the Prosecutor are complaining of. We are result-oriented people, but every piece of evidence, the judges have to set up a final deadline, intermediate deadlines for the different batches of evidentiary material, and every piece of evidence has to be, there should be a just reference to which requisite element of the crime or the individual criminal responsibility this piece of evidence is applicable, is relevant, sorry. And of course, two more points. The law for the specialist chambers and the rules of procedure and evidence quite wisely provide for the opportunity during the trial, while evidence has been presented by the prosecutor and by the defense in response, of course, that it is possible for the prosecutor to approach the relevant panel, the chamber, and to request the amendment of the charges by substituting the charges with more serious charges or adding some charges. Of course, as Dr. Tochilovsky was making a special point with regard to the fairness of the proceedings and the fair trial rights of the accused, sufficient time will be granted, but we know that the trial stage is the central stage, that the prosecutor has to present the full case with all evidence in his or her possession, and the pretrial stage has just to have the limited task of filtering good cases from cases that are not good to be sent to trial. So I'm very pleased in regard to this approach because that is how every domestic and international institution performs. And finally, on the evidentiary topic, we provided some very strict several rules on admissibility of evidence. And I will just read to you what this rule states. Unless challenged or proprio motu excluded, evidence shall be admitted if it is relevant, authentic, and has probative value, which is not outweighed by its prejudicial effect. This, of course, has to be coupled with the so-called in-depth analysis chart, because this will make the parties to properly study what they will receive. And by studying what they receive and the relevance, they will decide whether at all this evidence has to be admitted. Of course, we have also provided that the chamber, not like the ICC, has to receive the disclosed evidence. We are going to have access to the evidence. And we are going to do our homework. So, meaning when it comes to the admission of evidence, instead of spending days in this evidence is admitted, where actually no proper assessment of the evidence is done, and as we have discussed with Judge Smith, it's just fake admission of evidence. Every party and the chamber, having done its job, are going to, if there is an issue, to raise the problem. If not, then the evidence is admitted. So by this, we are going to first do a proper assessment of the evidence, but second, also to exclude evidence that is not relevant, that doesn't have probative value, and is going just to block the proceedings. And also a final point, we made it very clear that the standard of beyond reasonable doubt standard is going to be applied only to the subject matter of the case, to the facts constituting the elements of the crime and the mode of liability, and not to the individual evidentiary facts, as there is plenty of jurisprudence, of course, and we also reflected this in the Lubanga judgment, appeals judgment. And that also the judges have to assess and evaluate the evidence in a holistic manner, taking into account all pieces of evidence as a system, not the piecemeal approach, just kicking any piece of evidence out, then there wouldn't be criminal justice. We have just to lock the door to international criminal justice institutions. There are other innovations, but I took a lot of time. Thank you very much.
Thank you, Judge. I have a question, follow-up question. I think Fabrizio will address that issue also, but I will ask you, as you still have the floor. You mentioned the status conferences at the pretrial stage. Actually, they were made to expedite the preparation by the parties. And you mentioned disclosure. And I wonder if you had the situations in ICC when the defense would come and complain that we are trial ready, but prosecution is still investigating the case, produce new evidence, new material in disclosure. It's like moving target. We are prepared for trial, now we have new information, new material. How did you have this situation in ICC?
Well, actually, this is an issue that has been raised in the previous panels, and I'm against an approach that is going to be firm approach without any possibility to have the flexibility of deciding on the specificity of every case. As Mr. Keita raised the issue, there could be a situation where an alleged perpetrator against whom the prosecutor is about to seek to take some measures, and for example, the chamber has issued an arrest warrant, could be apprehended without the prosecutor having finalized the collection of all evidence. There can't be a compromise to this effect. So then there could be a situation when the government is not so hostile and would support the efforts of the prosecutor. In principle, it is very good to be trial ready, but this cannot always be the case. And then I always have been relying on the wisdom, knowledge, and of course the proper approach, justifying why they come with new evidence, meaning the prosecutor, but the wisdom of the judges to take a decision. But I wouldn't be stuck with beyond evidence that has been presented. In addition, it's inappropriate. This would turn the pretrial stage into a full-fledged trial. Is this what we want to achieve? No.
Thank you. And now, Fabrizio, before I give you floor, as you know, Fabrizio was at PrepCom, then he joined the ICTY, then he moved to the ICC. He's been everywhere, and that's why you can ask any question, not only for this panel. In your view, what is the balance, how you should keep the balance between the measures to expedite the proceedings and the rights of the accused, the opportunity for the defense to prepare its case, and what are the main factors, in your view, from the prosecution point of view, what are the main factors which slow down the proceedings? And my second question, it's linked to first maybe. In 2003, there was a group of experts set up to prepare recommendations for the ICC on how to expedite the proceedings in ICC, exactly the topic we are discussing. And one of the members of this group of experts was, again, Fabrizio. So maybe you can share with us your experience, whether those recommendations have been implemented in the ICC. You have the floor.
Well, thank you so much, Vladimir. It's really an honor to be here in this symbolic courtroom and in this great panel with so many colleagues and friends, and to, among other things, to have the opportunity to be again sitting together with Vladimir to discuss things that have been haunting us for the past 20 years. Thank you so much, Klaus, my dear friend and colleague, Klaus, former colleague Klaus Ragnitz, for the invitation. Thank you so much, Dr. Vivian Dietrich, for the invitation, and my new friend Eduardo Toledo, who I assume is running around somewhere for making all this happen. Going to the first question, 25 years ago, I was a PhD student in this wonderful country, 500 kilometers to the north. And one day, I had a moment of crisis, and I realized I wasn't really sure whether I liked my dissertation topic, and I thought about changing it for something else. And one of them was length of proceedings. So there happened to be a big meeting of German jurists in my town, in Münster. It was a Deutschen Juristentagen, which all the evidence came there, and the theme was length of proceedings. So I walked in thinking this may be the time to get the material that I need to go in a new direction. So I got there, and it was mayhem. And there was, explosions and people talking about the acceleration maxim, the Beschleunigungsmaxim. The rapporteur, Professor Karl-Heinz Gössel, was furious and talked about defense boycott of the proceedings. That led to a démarche of the Association of Criminal Defense Lawyers, who stood up and left the room and then came with a separate declaration denouncing the attempts to use the rights of the defense as a way to compensate for right of the proceedings. I walked back to my office with two things in my mind. First one was my dissertation topic was actually quite okay, and there was no need to change it. And the second one was that time and the criminal process are not good friends. This is true at the domestic level. This is very true at the international level. At the international level, it's a particularly complicated relationship. Now, Vladimir first question is, rights of the accused, what is the adequate balance? I don't think the problem lies, as Professor Gössel used to think 25 years ago, in an excessive or overly generous approach to the rights of the accused, certainly not at the international level. I think that there are areas where a certain approach to the rights of the accused leads to lengthier trials. And a number of times what happens is there's a conscious decision by the accused or by the defense to accept that in a way, right? For instance, one disclosure being one case in point. I mean, we disclose exonerating evidence to the best of our understanding of what the defense strategy would be. Now, a number of times, both in the ICTY and the ICC, we have asked defense counsel, if you give us the topics of your defense main themes, we will be able to run electronic searches to our collections and will be much more efficient in giving you the material that you want. The answer to that a number of times is, no, we're not going to tell you that, because if we tell you that, we'll be in a position to guess what our line of defense will be, and we're not interested in doing that. So we do our searches, and then what happens is, as the defense position becomes to crystallize in trial, for instance, through the cross-examination of our witnesses, we begin to understand the defense strategy in a different way. We expand our searches, and we give them more material on a rolling basis, apart from the material that we have given. We're doing the best effort that we can. Obviously, the defense choice not to share with us what they would consider to be the main exonerating themes in advance leads to perhaps a more protracted disclosure process that would otherwise be desirable. The second area is agreements as to facts. I mean, we have the possibility under the statute and the rules to sit down with the defense and agree to facts. The ICTY had the same thing. Now, when I joined the ICTY, the defense would, some defense teams would refuse to even agree to the fact that there was an armed conflict in the former Yugoslavia. So we have to basically establish as part of our case in chief that there was an armed conflict in the former Yugoslavia. Over time, we managed to persuade the judges that actually they could take judicial notice of the fact that there had been an armed conflict, because everyone knew that there had been an armed conflict. We experienced some of the same things in some of our cases. At times, we have been able to sit down with the defense and agree on a number of facts, in particular peripheral or contextual facts that basically shorten the presentation of evidence by the prosecution. There's not much that you can do when the defense refuses to do that, and it's their right to refuse to make any agreements. Now it becomes an issue of case management. At times, the judges may have to either say, well, we will take judicial notice of these things because we think that actually there is no need to to waste courtroom time in this. But by and large, my feeling is there is no issue really here in terms of balance. I think you can have a trial that takes place within a reasonable period of time in the context of international trials that are never simple, with full respect for the rights of the defense, and I don't think that the problem lies there. I think there are other structural problems that impact. One particular structural problem in the context of the ICC, and at times this is not really perceived when the output of the ICC is compared to that of the ICTY, for instance, if we don't have economies of scale in terms of within the ICC. So the ICTY had 25 years to work essentially in one big situation. Yeah. That means that over time you develop country expertise, language expertise, you know which are the groups that you're dealing with, you can build up your cases and repeat a lot of your evidence for the crime base, you can establish mechanisms to transfer evidence from one case to another connected case. So in a way, the process after a while becomes a fairly efficient process, and the judges, that's the other advantage that the ICTY had, more or less permanent judges, develop the expertise to manage a case, and they know as well, the context in which they operate and everything. For us, each new situation is a new learning curve. New languages, new groups, new terrain, new challenges, new logistical problems, new security problems. Every time we start from scratch. Every time we are the ICTY in 1995 trying to basically find a way through that mess. So that is a huge challenge, which is coupled with some of the problems that we have that come from the factory. The statute, the rules, they are very interesting and I think very noble as a blend of different legal cultures, but we operate in a context of normative rigidity. We can't amend the rules like this. Actually, we can't amend the rules at all. We can adopt provisional rules that then we send to the Assembly of State Parties, and we know that the amendment process in the Assembly of State Parties is by no means a simple one. And for instance, we have one rule that forces us to disclose to the accused all the statements that we intend to rely at trial in the language that the accused understands. All of them, not the main ones, not the critical ones, the totality of them. Now, when you're dealing with languages such as Fur, Sagawa, or Marsalit that are spoken in the Darfur area that don't even have a written version, good luck with that. But we had to do it. We had to invent a written version of Sagawa and Marsalit in order to disclose to one of our accused in one of our cases. It takes a long, and do you know how many translators there are in the world that translate Marsalit to English or French? Not too many, 3 or 4. So these are the challenges that we have to deal with on a daily basis. And each situation has a new challenge and a new language and a new problem. So that obviously has a big impact in terms of the ability to get to a stage of trial readiness, not only in the context of having completed your investigations, but be really able to present your case in court and to present your case to the accused. There are a number of other problems. Obviously, witness protection is a huge problem in the context of the ICC that wasn't in the context of the ICTY, because the ICTY operated in a context of post-armed conflict, and the redistribution of the population after the Dayton Agreement led to natural pockets of protection, right? So basically, the cases that I was working with, all our Muslim cases, witnesses were in the Zenica area, and the Bosnian-Croat perpetrators were in the Vitesse area, and it was unlikely that someone was going to go all the way from Vitesse to Zenica to retaliate against a witness. But we operate in context of ongoing armed conflict. The same armed groups that we're investigating are active in the field where the victims on our witnesses are located. That creates a huge challenge for us in terms of logistics, in terms of witness protection, in terms of moving people from where they are, give them a good cover story so they will not be suspected that they're cooperating with us, operating under the radar screen in those areas, and disclosure. You cannot disclose, I mean, it impacts on the timing of disclosure. The defense will receive all the identifying information that they did in due course, but you need to face disclosure in a way that at the same time caters for the rights of the accused. Now, if I can go briefly to your group of experts questions, Vladimir took me back to 2003 to a paper on length of proceedings that we had put together. And there were a number of recommendations, and a number of those recommendations we gave, and they have been adopted. to have lawyers with trial expertise from the beginning of the investigation, that has been done, to produce representative sample charges and focus cases, that has been done, to promote agreement to facts, that has been done. It hasn't changed much, but it has been tried. Practice directions from chambers. We have a practice manual coming from the chambers. The problem there is, it would be nice if all the chambers were following the practice manual. And at times what happens is the practice manual is there, but because it's not binding, it leads to one judge saying, actually, I'm going to deviate from the practice manual here, which is a bit of a problem. But the critical thing that we also recommended in 2003 was concentrated trials. Try not to segment the trial time, and that hasn't happened. And that hasn't happened because of budgetary constraints, among other things. So, for instance, just to give you a sense, the duration of the prosecution case in the Ntaganda case, the Ntaganda trial, was 20 months. But the amount of real courtroom time that we used was 8 months. In the Côte d'Ivoire 1 case, the duration of our case in chief was 25 months. The amount of courtroom time, of real courtroom time, was 9 months. So there is a mismatch between the amount of time that the presentation of the prosecution case is taking with the real amount of time that the presentation of evidence takes. And that is, among other things, because the registry doesn't have the budget to run 3 courtrooms in parallel. So we have trials competing for courtroom time and having to become inactive for a period of 2 months, only to then hear another chunk of evidence again. It's not an efficient way of doing business. But these are the challenges that we have. Limited resources, ambitious and rigid normative framework, and unique challenges that other institutions did not really have. They had other challenges, but perhaps not the ones that we're having. And at times, this creates a perfect storm in terms of the length of proceedings. So that's the wave that we have to serve.
Okay, thank you. Just one correction, maybe, that ICTY didn't function in post-conflict, because Srebrenica, Kosovo, victims protection there. Our next speaker is Dr. Michele Jarvis, also former ICTY counsel. She is now a deputy head of International Impartial and Independent Mechanisms on Syria. And my question would be first, your experience, ICTY experience, especially with regard to completion strategy. Hopefully it will not be relevant to ICC. I don't think they are going to complete their existence, but at least to expedite the proceedings, it may be helpful. And secondly, how, in your view, the mechanism may assist national and international jurisdictions on streamlining and expediting proceedings and trials on serious crimes committed in Syria. You have the floor.
Thank you very much. And I am conscious of the time, so I will try and give you the expedited version of my presentation. Maybe just to start, though, with a comment about what are we actually talking about when we talk about expediting proceedings. I think there are a number of different concepts potentially at play here, and all of them are important. And I think all of them we increasingly have lessons learned that we can really think about for the future. So, of course, we tend to focus on expediting the length of any given trial proceedings, any given individual case. And of course, that's an important objective, and we know that there are still things we can do to try and become more focused and move faster. Then we can think about sort of expanding out a little bit, expediting the proceedings against an accused person in total. And here I'm talking about the appellate proceedings as well, putting that into the equation. And I think that at ICTY we certainly learned that sometimes the measures to expedite the trial don't necessarily expedite the overall proceedings, and I'll come back to that later on. And then I think we have a really important discussion to have about how do we expedite the overall accountability process for a given conflict situation. And here I think we're starting to talk about some of the themes that have already come out in earlier discussions about how do we from an early stage start promoting connected action between actors in different jurisdictions and a more coordinated overall approach by many different actors, and how do we get the justice process complementing broader transitional justice objectives from an early stage as well. And that's where I think the mandate of the Syria mechanism, the IIIM, becomes very interesting as a new model of international justice. So if I look at just the sort of narrower version of this question, individual trials, I mean, certainly there were many, many lessons learned at ICTY over the years, and a lot of them were prompted by the completion strategy. Definitely the completion strategy had the effect of focusing attention on this issue, of really encouraging everybody involved, from the OTP, judges, defence, to think more creatively about how we could move faster. I think some of the strategies were really obvious, definitely not rocket science. Things like appointing ad litem judges, which just meant that we could move forward much faster with more cases in a more concentrated way, to pick up on your point, Fabrizio. So that was certainly something that made a huge impact on the overall time taken for the trials. Standby judges, where it was another advent after experience with some trials of protracted delays when a judge unexpectedly became unavailable, was important in these long, complex proceedings to make sure that things could still move forward even if one judge became unavailable. And that was the idea of having a standby judge who could step in and be fully prepared if the need was there. The impact of very active pretrial judges, I think, again, this is really obvious links with the comments made earlier about the role of judges in making sure that the proceedings are moving in a streamlined way. We saw dramatic impact from having pretrial judges who really took the reins and moved things forward. Perhaps a few things that are less often commented on in this context. Certainly we know the prosecution has a big responsibility for making sure cases are focused and that care has been given towards what goes into a case file. For example, we learnt that there were certain crime categories or even modes of liability options that were more evidence intensive than others, and where perhaps it wasn't really justified given the likely outcome at the end of the day. So to give you an example, the obvious one, of course, is charging grave breach crimes where proof of an international armed conflict is required. Proving that is incredibly evidence intensive, incredibly time intensive, and for many of our cases it just wasn't necessary because we could get the same result in terms of culpability with using war crimes categories or crimes against humanity. Not to say there are never reasons to charge international armed conflict related crimes. There are crimes committed in occupied territory, things that don't have a direct parallel. But I think the lesson is really, it should be a conscious decision-making process about what are we trying to get out of the charges that we bring. I think a similar lesson, perhaps less commented on, is the mode of liability around superior responsibility. This again, I think, if we step back from the ICTY experience, we see those charges tended to be incredibly evidence intensive. To prove effective control, especially in structures that were not traditional military structures, required a lot of evidence. Proving a negative, proving action wasn't taken, worked out to be quite evidence intensive as well. So at the end of the day, of course, at ICTY, we had relatively few superior responsibility convictions, in large part because it tended to be used as a safety net charge. We were, of course, always trying to get more direct forms of responsibility like joint criminal enterprise or ordering, but we would throw in command responsibility charges as a safety net. There are, of course, advantages to doing that, we know that, but I think, again, it's just a lesson learned about we should really think carefully about in which cases a charge like this is justified, mindful of the impact on, or potential impact on, the length of the proceedings. I think a lot of attention has been given to the move from oral evidence to written evidence at the ICTY. We saw it in a number of ways. We saw written statements going in instead of oral testimony. We also saw the advent of adjudicated facts, whereby the prosecution could seek to rely on facts that had been finally adjudicated in other cases previously. And I think all of those were useful tools, but there is a note of caution as well around this. Definitely the intention should not be to simply flood the record with as much written evidence as possible. It really does have to be a conscious decision about what evidence is appropriate to put on the record in written form. There are implications for witnesses too. A witness who has their evidence in chief go in written form and their only experience of the courtroom is an intense cross-examination. That's something to think about in terms of the overall interests of justice. Also, of course, what we gain in time, in court time, might actually end up translating into just more time for the judges to write the judgment, because the evidence is still there on the record in written form, has to be reviewed by the legal staff, and that can be time-consuming. So we have to be careful that we don't take too narrow a view of expediting the proceedings. In terms of looking at the overall proceedings, including appellate proceedings, here just a quick comment. We entered into a practice at ICTY whereby the trial judges tended not to adjudicate modes of liability that were charged as additional. So if a conviction was entered on a first mode of liability, the adjudication stopped at that point in time. What we found, though, on appeal often was that the mode of liability of conviction at trial was overturned on appeal, and then there were no backup findings on the other modes of liability. So in the worst case scenario, this could end up resulting in a retrial. So again, just to encourage a broader view about where we are making up time and what the implications might be through the process. Translation is really a significant factor, I think, for international courts and tribunals. It tended to be a source of significant delay at ICTY. I think there's no option when it comes to translating into the language of the accused, but I think the international community does have a choice to make about how many official working languages a court should have. There are lots of good reasons for having more than one, but if a decision is made to have more than one official language, then I think expectations have to be adjusted about what the time implications of that are going to be. And then when we come to measures to expedite the overall accountability process, I think Serge Bramat's already really talked about a number of these early on. The pyramid approach to cases at ICTY, I think that did result in significant efficiencies at the end of the day in cases like the Karadzic-Mladic cases. It was the building blocks that were established over the course of the tribunal's work that really allowed those cases to proceed in what I think was, given the complexity of the cases, quite an efficient way. It's hard to imagine that could have happened if they were the first cases prosecuted at the ICTY. Interestingly is this idea of how an international court's work can be a springboard for accountability at the national level, and this is very much where I think the IIIM is starting to try and incorporate some of these lessons learned. First thing is the evidence collection that the OTP established. We heard earlier 9 million pages, and of course videos and other material as well. Really an unprecedented collection of information about crimes committed during the conflicts. So for the IIIM, it's also very much the model of trying to use this time before other accountability pathways open up to make sure that we're collecting, consolidating, preserving evidence, having a central repository of that material that can service accountability proceedings wherever they might happen. Today, we of course have some activity in the national systems. That's really important. So figuring out procedures for this information and evidence to be channeled into prosecutions at the national level is extremely important. And if ever there is an international court or tribunal set up or referral to ICC, it would be the same idea. This collection of material would be available to expedite the proceedings as soon as the opportunity is there. Big lesson, though, of course, about just organising this huge volume of material. In the former Yugoslavia, it was already significant enough. In the context of Syria, it takes on additional dimensions. Again, it's the most documented conflict in history. The volume of video, social media, other types of evidence is just staggering. So one of the things that we have been doing at the IIIM as a priority is really putting in place the state-of-the-art information and evidence management systems, trying to avoid the problems that we've experienced in all the other situations of not being able to search effectively through our material, or not being able to track duplicates of material, or not having good systems for linking translations. Very practical, but make a huge difference to our ability to act expeditiously at the end of the day. So I'll leave it there in the interest of time and hand back to you, Vladimir. Thank you.
Thank you. It's interesting, both you and Fabrizio mentioned these adjudicated facts as the means to expedite the proceedings. But in ICTY, you had only one situation, is conflict on the territory of the former Yugoslavia. So you have facts by facts, and they become adjudicated facts, which is applicable to other cases, and it's relevant to ICTY. In ICC, adjudicated facts, you move from one situation to another situation, and those facts which were adjudicated in one situation are not adjudicated in another. So it is different. But because of the time, we will move to our next speaker. And it's in French. And I have no French, so I will try just to pronounce. Our next speaker is Maître Xavier Jean Keita, Principal Counsel, Office of the Public Counsel for the Defense at the International Criminal Court. So it's the party opposite to Fabrizio. It's the defense. And maybe you can cover the issue which Fabrizio mentioned, that sometimes it is the defense to be blamed for the slow proceedings at disclosure stage. Because without knowledge of the defense strategy, the prosecutor doesn't know which material is relevant to the defense, meaning that material which is relevant to the defense should be disclosed. But without knowledge of the strategy, how they can identify that material. On the other hand, I understand that defense say, I'm not going to disclose you my strategy. So how would you address that issue? I mean, the defense counsel.
Thank you, Vladimir. I cannot agree with the Office of the Prosecutor and Fabrizio on that way. I think that we have to see globally how ICC have been put in place. It was a treaty, and Rome negotiators were negotiating between common laws, civil law, and luckily for the victim participation, the civil law side was taken. In the other side, for the procedure, it was the choice of the common law. And I think the culture at this time was not to fight for justice. As a defense lawyer, I fight for justice. I don't fight against impunity. When you decide to fight against impunity, you give too much responsibility and power to the office of the prosecutor. How can we imagine a prosecutor? His DNA is to prosecute. Why you give the prosecutor the responsibility of investigating and to give spontaneously exculpatory material to the defense? And why the defense will believe that? Sorry. So the question of justice is question of truth in reality. And with that system giving, for me, too much responsibility to the prosecutor, we should have adopted the civil law system. You have a judge, independent investigating, coming with a truth, which is a truth of the institution, meaning that the situation, the case, everything is clarified to start a real case, and then the participant will come, and they will be given a limited time to investigate themselves. And you will have a trial terminated in 2 years. But if the prosecutor comes after 3 years with his truth, or semblant of truth, alleged truth, and then the defense is appointed Thursday because the suspect arrived, and there will be the first hearing, and after we have a confirmation of charges, the defense have to start and to try to come with its own truth. And in the same time, the victim will try to participate to the truth as well. So judges will face 3 truths. I think that this is slow down, this is not expediting the proceeding. As a defense lawyer, I have no reason to wait for the prosecutor to give me exculpatory materials. I have to investigate myself, and that will take time. So if we have decided in Rome that it will be like this, maybe it's time to give chance to the other way of starting a case and to put in place an investigating judge. Also, if you look the Rome Statute system, you have only one specific timeline and a limited time for judges, for instance, to decide. It's to confirm or not to confirm the charges. 2 months. Yes, 2 months. 60 days. Apart that, there is no limitation. Defense, prosecutor, we have often limited time to send our filings and to comment this or this, but no limitation for the judges. I think that if we want to expedite the proceeding, we have to put deadline to each time of proceeding, each time of level, to say that, for instance, a trial will take, I don't know, 1 year or 2 years, and not more. When you look, Lubanga arrived in March 2006 in the court in The Hague. His trial started January 2009, and the first decision was in March 2014. And you cannot pretend that this is a good timeline for justice. You take Bemba, since his arrival to the final decision of acquittal, it took 10 years. I think that we can also modify some regulation, for instance, to give more security during a trial. As a defense lawyer, I'm not secure by charge confirmed or not, because you may have some sub-charges and additional research from the additional investigation from OTP, and even judges, they can decide to, at any time, to recharacterize the charges. It's Regulation 55. So you don't have security, and you are obliged to adapt as a defense lawyer and to change your strategy. Look what's happened in Katanga and Gujolo. So during the deliberation, there were a recharacterization. And I also think that we have to find a way to focus on precise charges. Is it necessary, for instance, for OTP in Ongwen to have from 7 to 70 count of charges. Is it necessary to have so much count to demonstrate the alleged criminality of Dominique Ongwen? I don't think so. I don't think so. I think as well, if we want to expedite the proceeding, we should, for instance, invite the chamber to make an early assessment about the evidence communicated by the party, instead of postponing that to the end of the trial. Also, another proposal, interlocutory issues. Very few of them are granted. And for me, it's not in my culture to ask the judge who rendered a decision, and I disagree with the decision, you go to see the same judge and to say, can you allow me to appeal your decision? They are unhappy. They don't grant it. And I think that certain issue will have an expeditious way to be solved if systematically those appeals were granted, and we have another view coming from the appeal. Also, another proposal, and I'm not from common law, as you know, but I think that we should use more often this no case to answer. Why? Because it's not in the text, but it's have been utilized, and I think it's good. It's a way to shorten the proceeding and for the judges at an earlier stage to say if yes or no, they consider they have sufficient consistent evidence after the prosecution case, instead of going directly to the defense case. We stop and we make an assessment, and things can be shorter. Another possibility to expedite things, it's about the budget. First of all, I consider that the court, there are a lot of expectation about the court, even if we are often criticized. But look our budget. I think it's 148 million. I'm sorry, this is a low-cost justice budget. We are a Ryanair justice, a kind of Ryanair justice. We need a decent budget. OTP need more means to investigate. I'm sorry, yes, as a defense lawyer, I think that OTP need more means because they have a lot of responsibility, the defense as well, and maybe the victim as well. But we need to be more ambitious for that. And the budget for the training, OTP budget for the training, and it's good for them, 290,000 euro. 290,000 euro, the training for OTP. My office, 600 euro. And we train counsel. But the registry have more budget, 600,000, but they train all the court because the registry is servicing everyone. The registry also organize trial for counsel once a year, or a regional one. Is it decent and efficient to train counsel, those who are daily facing OTP? I think not. So if we have a same level of training for all actors, I think that will expedite. We'll have well-trained counsel in OTP and in defense, and I think that can expedite the trial. My last suggestion is, of course, to have the defense as an organ, and at a higher level, defense will be involved in decision, because you were talking about a working group thinking in which Fabrizio was involved, but the defense was not involved in those groups. Only my office was invited at the later stage, but I don't think that external counsel, those who are practitioners, are invited. So they are practitioners in defense side, and they should be included in those reflections to expedite the trial. These are my quick suggestions.
Thank you. And now we have, you have the floor for questions. You have a question? Please.
Thank you very much. Thanks a lot. It was very instructive. I had a question. We're going to talk about that tomorrow, but now that I have the panel in front of me, I just wanted to throw this at you. In terms of victim participation, to what extent do you think, and well, before I ask the question, what Michele said, I think, was very instructive, that in order to evaluate whether something actually delays or not, you have to look at the entire duration, the entire life of a process, of a life cycle of a proceeding, in order to say, has this actually rendered things slower or faster? In that light, would you think that the addition of this entire victim participation docket into the ICC proceedings has actually, under the line, under the sort of the general equation line, rendered things slower, or is it maybe the same? Is it worth it? Thanks.
Patrycja Grzebek, University of Warsaw. I wanted to ask you about an argument which is used mainly by American scholars, but they said that the long trials before ICTY and ICTR, this is the result of the focusing on the history of the conflict and not on the guilt of individual persons. Can you observe in contemporary trials that maybe you mentioned the problem that we had to analyze if the conflict in former Yugoslavia was international one, but do you see this problem that maybe the focus to understand the conflict, to understand why we had such hatred between some ethnic groups, maybe this is something which we could skip and then we can save time. Thank you.
First of all, thanks to all panelists, I think, for a fascinating and great contribution. I have three questions. One relates to what Michele already alluded to, the changing role of new technologies and open source evidence. How will this affect actually proceedings in the future? Will they become faster? And what does it also mean for the balance, for the quality of weapons between prosecution and defense? Doesn't it create an imbalance, and will it not be even more difficult for the defense to challenge some of it? My second question relates to the recent developments in the context of the Rohingya situation, the question whether in order to expedite proceedings, sometimes it might be helpful for the prosecution to actually seek advice from the pretrial chamber early on during the preliminary examination phase in order to settle issues early, in order to prevent that they become a bottleneck in the situation. Think about Israel, think about other situations where they're very complicated jurisdictional question arising. So we don't have that advisory procedure in the statute. We had a mixed bench. So I would like to hear from you whether you actually think it's a good way to have a kind of advisory a possibility of this kind. And the last question relates to the completion strategy, whether the ICC would actually benefit from a kind of completion or exit strategy in relation to situations, and how this actually has been approached yet. Thank you.
No further questions. The first question is about victim participation, whether it's prolonged the trials. Who will take? You and the judge. Okay. You have the floor.
Maybe, of course, I was very much involved into the victims issue, and if we are going to go back to the first years of the ICC, you remember that there was one first decision in Lubanga whereby Judge Blackman only dissented because the two other judges, Judge Fulford and Dodio Benito, decided that any potential victim of crimes in the abstract falling under the jurisdiction of the ICC, regardless of whether there is a pending case or situation before the ICC, is eligible to apply. So this was, of course, rightly so overturned by the appeals chamber. Then there was a time when judges were going through every single application, not taking all the potential of the victims' participation reparation and victims' participation office, VPRS and OPCV. Also, there was a time when the application form was 17 pages. Then it was reduced to 7. With Ms. McKay, we reduced it to 1. That just reflects what are the requirements of the law, and that is it, nothing beyond this. Undoubtedly, then there were some practices whereby victims were granted the status of victims even before the issuance of a judgment, which was, in my humble view, inappropriate, because I'm supportive about this innovation without any doubt, but there should be a meaningful victims' participation, meaning that they have to be admitted and there should have been a deadline set before the actual commencement of the prosecutor's case and thereafter the defense case, so that they can make a meaningful contribution where their rights pursuant to Article 68 might be affected by the issue at stake. So I think that a lot has been developed with the ICC, meaning that the VPRS is assigned to do most of the assessment, grouping of victims, the legal representative, the collective victims' reparations. There was a little bit shift again back to the initial practices, which in my, again, that is my personal view. I wouldn't like to in any way appear to be very critical, but there was 1 year and a half lost time when the harm suffered by any victim had to be assessed, which was in addition a lot time consuming, and also the budget, instead of being used for the purposes of the whole affected community, not only victims who have been accorded the status of victims, but the rest that were not covered by the prosecutor's case, which would have created much more conflict among the people that suffered of the same crime. So I think that the ICC now is making some very good steps. Victims' participation shouldn't be abandoned, but it has to be streamlined. Common legal representative, collective reparations to the extent possible, because the trust fund for victims, when they go, there is an instruction in the judgment, the appeals judgment where I participated in Lubanga, dictating to the trust fund, when you go to the field, you're going to provide assistance, support for the affected community, but with regard to the individual victims, when they have suffered individual harm, and when that could easily be handled by the resources of the trust fund, you're going to do this. So there should be a pragmatic approach driven by good intentions, not delaying, and that victims do not wait for the assessment of every single victim who suffered, for example, a scar, or anyway, I wouldn't like to go into more details. I have been critical about this, but apart from that, I think that victims' participation is gaining momentum. Quite well done. Thank you.
If I can, as much as I disagree with Judge Trafirova on the in-depth analysis chart, on this one, I'm in full agreement with everything she said. No, I think that was a perfect answer. The only thing that I would say is I think it would be both inaccurate and grossly unfair if we blamed on the problems of the ICC's length of proceedings on victim participation. And it is one area where we have made progress, we have streamlined, we have turned the process into a more efficient one. It has been that one. And I think that properly controlled, proper case management, with a clear identification of what they should and should not do in the trial, victim participation not only is not a problem, but it is immensely beneficial to the court. It provides an anchorage with affected communities that otherwise is lacking. It gives that connection, that brings it down to earth. We've seen it in the Ongwen case, how important it is to have victim participation, how important it is to have the legal representatives going back to the field and having town halls and talking to the victims as to how the trial is progressing. We've seen how connected to the outreach, how it really gives a sense of ownership of a criminal process, otherwise would be completely strange in an ivory tower in The Hague. So I think that it's an opportunity in a number of ways. I think it's the right thing to do. It has to be controlled. I think there was a tendency at the beginning of some sort of populist approach to victim participation, which is completely gone. But I think that it's not really a problem. It has to be controlled, but it's not really a problem.
Thank you. Before I give you the floor, we have 4 questions, and each speaker will have seconds to answer. So you have the floor, please.
So on victim participation, I think that we have to remember that the court have been created because we wanted to stop this violence. Those who are victims, we cannot pretend that they are responsible if proceeding are slow. But I said that the common law procedure was the one put in place. So you have 2 parts fighting, defense and the prosecution. So victims are participants. And Article 68.3 said that they may participate at any stage without being detrimental to fair trial. Look what's happened in Bemba. Victims, 5,000 victims were admitted, but at a stage very late. So the chamber have decided to avoid from the request, from the defense a request of a release of Bemba. The chamber have appointed my office to analyze for the defense, for the Bemba defense, those 5,000 victim participation. Well, we have done that. I think that it's a risk when that happen at a late stage. It has to be organized earlier. Second, I think that victims gain more and more power, for instance, participating to the evidence, the truth, and that have to be balanced a bit, because OTP and defense, they have rights, but they have duties. And if you give more and more rights to victims, non-balanced by duties, this dual fight will make that the defense finally will face a second prosecutor, and that is a risk in the balance of the proceeding. I am totally in favor of the participation of victims. And I even have a suggestion. After what's happened to the victims, I was the first disappointed after Bemba acquittal, because victims suddenly were without solution. Why? Because our proceedings are linking the reparation to the victim directly to guilty or not guilty. And I think that if we have in a situation country victims, it's because the state of origin failed to protect them. So I will put in place a direct responsibility to the states. And if they cannot, the international community will take its responsibility and not to wait to have someone responsible or not. Immediately, victims have to be taken for reparation together with the trust fund, and not to wait to give them expectation because they are participating. That's good, but not to depend on the result of a trial. This can be changed, and this will be totally in favor of victims.
Thank you. So we have questions to Michele on technology, and then Fabrizio on preliminary examination, and maybe also Fabrizio or anyone else will also address the completion strategy for situations. Please, you have the floor, Michele.
Thank you. If you don't mind, I will just add a quick comment on the question on context. I think that was a really important question. Just to say, I think that we have to recognise that context and evidence about context is always going to be key to core international crimes prosecutions. I mean, that's really one of the factors that makes these cases so different from domestic criminal cases, ordinary crimes. But definitely, I think anyone involved in international justice from the early days, I'm looking at someone like Brenda Hollis involved in the Tadic decision, the Tadic case, I think we can certainly see opportunities for streamlining this type of evidence from perhaps what was done in some of those early cases, understandably, because for the very first case, how could the prosecution possibly know what the court was going to require or what would come out in the judgments at the end of the day? Now I think we have a better idea about the evidence, what's sufficient in order to prove the particular elements, so we can be more efficient on that. I think we've learnt lots of lessons also about how to use overview witnesses and expert evidence for expediting these methods of proof, and that's something that we can continue to think about more in relation to other categories of crimes as well. Sexual and gender-based violence is an obvious example of this. I think we haven't tended to use expert evidence in the same way as other types of crimes, but we could do better on that. And just on the issue of SGBV, I just wanted to make a brief point that I didn't manage to make in my presentation about the fact that this objective of expediting the proceedings can really be in tension with accountability for certain crime categories like SGBV. We know that often there is delayed reporting by victims of this category of crimes. So I think we just have to bear in mind that the objective of moving faster does have some, influences, impact on the proceedings in other ways that we have to be mindful about. Just to then quickly answer Carsten's question about the impact of new technology, is this going to help us expedite the proceedings? I think that overall there is real opportunity there. The experience that we've had at the IIIM so far is that setting up the information and evidence management system, the tech side of our work, has actually been time consuming in and of itself. There's a whole range of reasons for that. Part of it was we had no idea really what format, volume, structure, the material that we would be receiving from others would have in the context of Syria, so predicting what kinds of systems we need was difficult. And then of course a lot of this software wasn't available within the UN system, so we had to procure it all inside the UN system, and anyone who's familiar with that process knows that that's not something that happens overnight. But I do think that it was a worthwhile investment, because I think the gains through the process in our ability to efficiently process the material will have real impact, hopefully for the defence as well, actually, because one of the problems that we saw in situations like the ICTY was the difficulties in managing the volume of material, especially over time, meant that disclosure to the defence was often more complex than it had to be. We couldn't identify duplicates, and so instead of having one document, the defence might get 10 copies of the same document, that sort of thing. I think with these systems we should be able to head off problems like that, and it should make it easier. But of course it is obvious that if the prosecution is being geared up with these new tech solutions, then there has to be a reciprocal capacity within the defence teams to deal with those evidentiary sources. Thank you.
Yeah, I have 2 minutes just briefly to talk on the last two questions on the Rohingya situation and the Article 93 ruling. It's a difficult balance to be reached there. I think that the considerations behind our request for an advanced ruling or a preliminary ruling on jurisdiction are global ones, right? So they could apply to other situations. In the sense that we said, well, we would like to get certainty as to these jurisdictional elements before we open a preliminary examination, and much less an investigation, only to find out in the 11th hour that we have invested 3 years and a lot of money into a situation that basically you consider to fall outside the jurisdiction of the court. We also made it clear that this is not something that we are going to resort to as a matter of course. We made it very clear that basically we are going, if we are satisfied that we have jurisdiction, we will move forward without seeking any preliminary ruling from a pretrial chamber. Only those areas where we recognize there is a genuine question that has to be solved. By definition, I would consider those areas to be on the fringe, to be a bit on the margins of our situation. But so in a nutshell, it's not a procedural device that we're going to resort to routinely. It's going to happen very, very exceptionally. In terms of the question on completion and exit strategies, the moment we started to work on our case selection policy, we said, well, the other side of the coin is the exit strategy per situation. It's a much more challenging analysis. It's a much more difficult determination to make. There are a number of questions that had to be addressed. Do you exit a certain, or do you complete a certain situation before you have been able to complete your full prosecutorial program? Richard Dicker was talking earlier about your vision. Well, what is your prosecutorial program per situation? Is it a good idea to abandon that situation or to exit that situation before that program has been completed? Could you do it when you have outstanding warrants of arrest? Even if those outstanding warrants of arrest have been there for a long time. Our experience would militate against that because, for instance, one of the reasons why we could successfully reinvestigate the Onwen case 10 years after the first investigation was that we had kept field presence, we were in touch with the communities, we were in touch with the witnesses, so it was relatively easy to go back to the field and start putting the case together again. At the other side of the spectrum, in other cases, we were absent from the field for a prolonged period of time. When we came back, because we had to supplement the investigation after someone had been captured, the answer from the communities was, well, where were you guys for the last 7 years? And now all of a sudden you need us again, and now you're coming to talk to us? So there are a number of really sensitive and difficult factors that had to be considered. It is easier to select within a situation than to consider the situation to be completed in the context of the ICC. And in the context of the ICTY, it probably would have been the same. We could have stayed happily prosecuting a situation for a long time, I think, most of us. But at one point, someone said, time's up. So, yeah.
Thank you. There is no time left for any concluding remarks, and I will be very concise. The problem, the issues, the question how to expedite the proceedings is not easy. You have to balance various factors. And the first proof of that is our panel. We're out of time. We failed.
Never give up.
And it is my fault, of course. But I would like to thank our speakers for comprehensive cover of these issues. Thank you very much.